student. She's in her third year at the University of Richmond right here in the city. She's originally from Richmond and graduated from William & Mary with a BA in History and Anthropology in 2007. Amy Weiss has been an activist in support of women's reproductive health for years. She was involved with their college chapter of Vox, the Voices for Planned Parenthood, and the current activist chair at the University of Richmond chapter of Law Students for Reproductive Justice, Amy Weiss.
Thank you very much for that lovely introduction, and thank you very much to each and every one of you for being here to help protect women's constitutionally protected rights. So we all know what's wrong with this TRAP legislation from a common sense and a morality standpoint, but I'm going to talk a little bit more about some of the legal problems with it. Some of these issues are a little bit complex, so for the sake of time and everyone here, I'm going to keep it general. So first I'm going to talk about the constitutional right for a woman to choose to have an abortion as it stands now. And then I'm going to talk a little bit more about some challenges to the TRAP legislation. As we all know, the word abortion does not appear in the Constitution. In fact, the Constitution is silent on a lot of issues that the Supreme Court has decided cases on. But what we do know is that Roe v. Wade, which was later affirmed in Planned Parenthood v. Casey, that the Supreme Court recognized the right of a woman to choose to have an abortion. Of course, the Supreme Court also recognized the state's interest in protecting the potential life of a fetus. And this is the balancing approach that we must take in determining whether state restrictions on abortion access are unconstitutional. Casey was a blow to women's reproductive rights movement, in that the court held that the state could regulate abortion even before the fetus reached viability, which is when it can survive outside the womb. But the court did uphold the core holding of Roe and held that the state could not impose an undue burden through substantial obstacles to a woman's access to abortion before the fetus reached viability. In Casey, the Supreme Court recognized that the woman's right to choose is a fundamental cornerstone of equality. And the opinion stated, for 2 decades of economic and social developments, people have organized intimate relationships and made choices that define their views of themselves and their places in society, in reliance on the availability of abortion in the event that contraception should fail. The ability of women to participate equally in economic and social life of the nation has been facilitated by their ability to control their reproductive lives. The Constitution serves human values, and while the effective reliance on Roe cannot be exactly measured, neither can the certain cost of overruling Roe for people who have ordered their thinking and living around the case be dismissed. Today, the right of privacy and a woman's 14th Amendment liberty interest in choosing how to treat her own body are under attack. Since the Casey decision in 1992, state legislatures have pushed the limits of the undue burden test to pass all sorts of legislation and regulations, from consent requirements to waiting periods and mandatory counseling. And as we are here today for the TRAP regulations, even though it is clear, goodness, that the real intent of these laws is not to protect women's health or make the procedure safer, they're a thinly veiled attempt to shut down as many abortion providers as possible with detrimental effects on women's lives. I'm going to quote one of my favorite parts of the Carhart versus Gonzalez dissent, written by Justice Ruth Bader Ginsburg, where she wrote, "Legal challenges to undue restrictions on abortion procedures do not seek to vindicate some generalized notion of privacy. Rather, they center on a woman's autonomy to determine her life's course and thus to enjoy equal citizenship stature." The The recently passed TRAP legislation is exactly the type of substantial obstacle to abortion access that the Supreme Court held was unconstitutional in Planned Parenthood versus Casey and is in flagrant disregard of the 14th Amendment due process right to liberty. I thank you all for your attention today, and I thank you again for joining me in the fight for women's health and equality against the